Hi everyone, it's me, Lauren Cadilac, Cadillac Law. I'm coming back to you with part 2 of the Ahmaud Arbery closing arguments. So in the last video, we watched the prosecution and the defense number 1, the first defendant's lawyer. Now we're going to watch defense 2 in parts of the third defense lawyer. The third defense lawyer? Yeah, second defense lawyer, third defense lawyer. Okay, so before we get started, first I just need everyone to know I absolutely love her suit. I don't think I would wear this suit to do a closing argument in front of a jury, but whatever makes you feel the best in the world is what you should wear, and that suit is everything. So, good for her. Here we go.
This sickness that you would need to find beyond a reasonable doubt to find Greg McMichael guilty of malice murder. That's why I suggest that you begin with count 1 and quickly dispatch of it with a not guilty verdict.
Ooh, quickly dispatch.
And then move down to the remaining counts, counts 2 through 9, because it comes down to this. If Greg McMichael was authorized by law to attempt to execute a citizen's arrest, to try to detain Ahmaud Arbery for the police to come and do their job, to try to keep peace and safety within that neighborhood, then they were within the law to hold him there for the police. How else does one hold an individual who does not want to be arrested for the police? You have to contain him, not false imprison him, contain him. You have to possibly hold him at gunpoint without firing a shot, not an aggravated assault, but the use of a reasonable and measured amount of force to make him stay where he did not want to stay. So if they were acting within the law in trying to execute a citizen's arrest, to detain Ahmaud Arbery for the police, then Travis had every single right to defend himself. When Ahmaud Arbery inexplicably took that sharp left turn at the right front of the truck, seeking to disarm Travis McMichael.
I wonder why.
So,
our last 2 people really walked around. They call it the well. That's like the free space in front of the jury, whatever. And the last 2 attorneys that did their closings, they walked the well. They were pacing around, as we briefly mentioned. She is just staying at her podium. I find that to be interesting. I like her old school demonstrative here. I'm into demonstratives, so and I like the old school ones like that. Old school being handwritten.
Who's got to prove what? We begin, as we always begin in a courtroom, with innocence. And we stay there unless and until the state proves to you that this was not a citizen's arrest and that Travis was not justified in defending himself.
I love that because it's true, right? You're innocent till proven guilty. And I love how she said it. We started innocent and we stay here. And now if I'm a juror, I'm like, ooh, okay. So far, I like her presentation. I liked the first lady, the second guy, this lady I like.
Himself against Ahmaud Arbery's attack. And they have to convince you of that. Remove your belief in that citizen's arrest or justification to such a degree that you've got left nothing in your minds to doubt it. And that sounds like an enormous burden. Why? Because they have to make you sure of it. You have to have no hesitation, no ambivalence, absolute certainty, because the stakes are as high as they come. It's the highest level of proof we ever ask for in a courtroom. The court will tell you when they say murder and the facts raise justification, and the judge will tell you justification is self-defense. Justification is citizen's arrest. That when the facts are raised to support those defenses, that the state has to disprove them, that you were justified. But why? Why is the standard so incredibly high? And the answer is something you witnessed in this very courtroom. Even in science, errors can happen. And without diligent investigation.
A little bit ironic that she's saying, you know, we need to do this beyond a reasonable doubt, and that burden is so high, and the state has it so high, when her client took the ability for the state to make those arguments away from another man, you know, about another man, away from him. Okay, so here, let's see, quickly, it looks like she does.
Reasonable grounds of suspicion is nothing more than probable cause. And probable cause, as Mr. Sheffield and the court will tell you, are facts necessary to establish a probability, more likely than not. It's less than certainty, but it's more than mere suspicion. So think of it this way. If Officer Rash had been on one of his patrols in Satilla Shores. I
totally use handwritten demonstratives like that. So I like what she's done. You see her kind of move.
But most importantly, what we now know is that Greg McMichael fought in the panic and adrenaline and fear and of that horrible situation. He thought that's what he said at the very end of this encounter. Mr. Hogue cross-examined every witness who was with Greg McMichael when he shared that piece of information. The DA wants to make you think, by cherry picking, that Greg McMichael said that anywhere, anytime, over and over, all through.
So remember, these are closing arguments. So she can say that the government is cherry picking their evidence, and you know she's allowed to make those type of arguments right now. So that was interesting in that I'm surprised she stayed behind the podium like that. I think she did a good delivery, and I like that she emphasized, you know, the state's burden. And I feel like if I was a defense attorney, that's what I would be doing. State's burden, state's burden, state's burden. So.
Al videos from his house, the videos that had been overlooked in the canvassing of the neighborhood, because he was down at the police station. He gives them his.
This guy's been taking notes the whole time.
Social media. He gives them his Facebook. Ladies and gentlemen, without Roddy Bryan, there is no case. You will have to decide what justice looks like between the McMichaels and Mr. Arbery, between the McMichaels and the Arbery family. But the reason that you can do so, the reason that we can have this trial, is because of Roddy Bryan. Roddy's decision to cooperate with law enforcement to help them discover the truth about.
Okay, if you recall in the first round, the prosecution's argument, she kind of she alluded to this was going to come up, and she mentioned just because you help the police after the fact does not take away that the fact occurred or that you did the thing. So she must have anticipated, or like I said, I didn't get to see the trial. So somehow this came up during the trial. And so she knew that this was something this man would be approaching. And that's why she kind of preemptively went for it.
About the events of February 23rd, 2020 is not the product of slick lawyering. And had no lawyer on the side of the road in the minutes after Ahmaud Arbery was shot. It was not some lawyer. It was Roddy Bryan without any lawyer. without any help, without any assistance.
See, now, prosecution is not allowed to talk that way, like, oh, he was without a lawyer or whatever. I really don't feel the defense should either. That has nothing.
Making that decision on his own. Roddy Bryan.
Investigation does not help prove or disprove innocence. So I don't like as much where he's going, whereas the last attorney, where she's like, here's the elements of the law, and she kind of like stuck with that. I know it was short, but she had the demonstratives, and this is probable cause, this is reasonable doubt. The government has this burden, the government has this burden, the government has this burden. He's not playing that same thing. Now, he's benefiting from her having just said it, but if only one of them was going to be the closer, I would have chosen her.
Made the choice. Roddy Bryan decided to invite Officer Minshew to sit with him in his truck, even before Roddy Bryan has a chance to look at the video himself. All this again without a lawyer. These actions, ladies and gentlemen, demonstrate good faith. His conduct negatives any inference of criminal intent. Who is Roddy Bryan? Roddy never served his country like Travis McMichael, but for the actions of Robert Rash and Diego Perez.
He's also staying behind the podium, which I find odd. I don't understand why the first two were walking the well and the second two are staying behind the podium. I don't know if the judge told them they needed to or what. I missed that part, but I do find that a little odd. Also, you'll notice he does not have a demonstrative. I can't even tell any other lawyers out there, like, demonstratives help. They give people something to focus on, and I think he should have one.
This incident might not have happened. But for Mr. Valbenzi calling the normal police number instead of 911, the police might have responded faster and things might have been different. But for Mr. Albenzi cutting off the Satilla Drive exit, Mr. Arbery might have escaped. But for 100 different things, all of which had to come together in the exact sequence for this tragedy to take place, it could not have happened. So simply saying that but for Mr. Bryan being there that day, that's not the standard. And the state doesn't even try and meet the standard that the court is going to instruct you on. And maybe they're just waiting until they have the last word.
Another thing is the court had given instructions to the jury in the Rittenhouse. He gave the instructions to the jury before the closing arguments. This time, the jury has not yet had the instructions, so they're just going through part of the trial. They're going to hear the closing arguments, then the judge is going to give him instructions, and then he's going to send them back to deliberate with a copy of the law.
Word. And all I can say about that is that's just dirty pool, and I certainly hope that's not what's going on. Now, again, with all respect to the state, who have some very capable lawyers, when we look objectively at the events of February 23rd, I would respectfully submit to you that Roddy Bryan's presence is absolutely superfluous and irrelevant to the tragic death of Ahmaud Arbery. Now, that may not be intuitively obvious, but if you...
I like, though, that he is trying to, like, I don't care what you do with the other two defendants, but my client, he had nothing to do with this. He helped. He made the video. He showed this. He did not murder this guy. I do like how he's trying to pull that. I don't know if it'll work. I mean, we'll see. We'll see what the jury says. But I do like that strategy.
If you think about it, I believe you'll agree. Had Roddy Bryan stayed in bed that day, if Roddy Bryan had stayed on his front porch, would Ahmaud Arbery be alive today?
Probably.
If the state's theory is that these men, and I'm not saying that's the case, you decide what the deal is with the co-defendants, but if the theory is that these men were vigilantes and harbored some ill will towards Mr. Arbery, then what difference does it make whether Roddy Bryan is there or not? Mr. Arbery can't outrun bullets. They've been chasing him for a while, and he's at practically point-blank range even before he comes around the truck. The problem is, for the state, that Mr. Albenzi, thankfully not indicted, not yet anyway, Mr. Albenzi is down the street with his firearm. Roddy Bryan doesn't know that. That's why Roddy Bryan goes down Satilla momentarily. That Mr. Arbery was. And I don't say that as a measure of disrespect to Mr. Arbery. That's just what the testimony is. And I think the state questioned that. I could be wrong, but if I could remind the jury, I believe during the testimony of Special Agent Jason Sechrist, during that testimony, I believe I specifically referenced page 54 of that transcript. There's a time there when Roddy Bryan is testifying, and he says, he's coming back at me, and I'm like, oh, blank, excuse me, again. And I started a kind of evasive action, which we see on the video, and dropped the phone. So, long before Mr. Bryan has any reason to believe that anybody else has seen this, he's provided that information. Getting a look. What time is it? Oh, okay. Getting back to Mr. Bryan's statements, as I've indicated,
I feel like he just asked her how much time he has left, and she was like 20 minutes, and then he just sighed in exhaustion. You don't have to take every minute they give you.
disregarding a substantial and unjustifiable risk that his act or omission will cause harm or endanger the safety of the other person. And the disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise. I would suggest to you
that sentence right there is why demonstratives are where it's at. So the last defense attorney, she had that like little chart and it was real bulleted. And then he just said blah, 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 blah. The law is really, really complex. And there's all these like but-fors and ands, ifs and nors and da-da-da-da. So in a demonstrative with a chart, the way she had it, you could see that. What he's doing is just like on and on and on, and it's hard to understand.
That Mr. Bryan did not consciously disregard a substantial unjustifiable risk in operating his motor vehicle. We would submit to you that Mr. Bryan did not commit any offense in the operation of his motor vehicle. But this is before you, and if you decide that you believe Mr. Bryan's guilty of that, then Mr. Bryan will have to live with the consequences. We have 2 counts left, and Your Honor, I'm getting a look. And I don't know whether that means...
From whom?
I think the jury might want a break. It's there. That's up to them.
Head shaking no.
Head shaking no. Okay. Well, then that's the...
What is he doing?
answer. Sometimes when people are shaking their heads, you don't know what they mean. All right. Sometimes people are shaking their heads, yeah, he's crazy. I get it. All right, let's talk a little bit about false imprisonment. Mr.
Oh my gosh. I don't know. I don't know what that was. I feel like he could have ended a minute ago. He would have been just fine when he checked the time. Or just do a brief recap. Here's what you saw. Here's what you didn't see. Here's why the state didn't meet their burden.
Bryan never denied following Mr. Arbery. Mr. Bryan has never denied, quote unquote, angling his vehicle ahead of Mr. Arbery, although he did not use the words this in some detail. I'll try to avoid that same ground. First, where there is no confinement, no detention, there can be no false imprisonment. That's the law. Pretty basic. Mr. Arbery never really stopped.
Okay, so now here's the law. Here's the factual.
Never submitted.
Finally.
I think the state's position was that Mr. Arbery resisted to the end of his life. And in saying that, I mean no disrespect to Ahmaud Arbery. I do not wish in any way to lessen the magnitude of this tragedy. I'm simply applying the relevant law to the facts. I'm going to use a different example to
That's
kind of
what
illustrate the point.
our jobs as lawyers and jobs as judges, and then the job of this jury is just to apply the law to the facts, like all the things that surround it and the oh but this and the oh but that. No, law, fact, application. That's it.
Point I'm trying to make. I try to be humorous at sometimes the humor is not successful. If it's not, please don't hold it against Mr. Bryan. To illustrate the point I'm trying to make here, let us consider the classic example of a bank robbery. A man with a gun enters the bank and yells, "Get down on the ground. I will shoot." There are 3 customers in the bank. The first is a lawyer. The second is a school teacher. The third is a college freshman listening to music, texting a girl, and late for class. Now, instead of getting on the ground, and before the robber can even finish his thought, the lawyer foolishly asks, "Hey, don't I know you?" The lawyer gets shot. He instantly dies. This is murder, or felony murder. However, this is not false imprisonment. The second customer, the school teacher, says, "Please don't shoot me. I have children. I'm taking a busload of kids to the museum." She gets on the ground. The school teacher has complied with the robber's commands. She's shaken but otherwise okay. The school teacher, she has been falsely imprisoned.
Oh, y'all.
The third customer,
He's not falsely imprisoned because he's dead is not the greatest. It's not a good defense.
college freshman, for whatever reason, ignores the bank robber. The college freshman says nothing, but runs out the door just as fast as he can. He never looks back. When his parents call later that day asking how he's doing, the college freshman doesn't even mention his near-death experience. The college freshman, although certainly fortunate to be alive, has not been falsely imprisoned. Likewise, in the
Okay, well, that was a better analogy, but yeah, it's interesting watching the styles of these other lawyers. Again, the walking around the well, it's very different that before lunch they were doing it and now after lunch they're not. So I don't know what happened there. The demonstratives help. Obviously, they were great for her and they kind of keep focus where it should be. This guy's using some really good analogies, though. I love analogies. I've already told you that in another video. I think analogies are a great way to win. They bring things to a really understandable level. So this is interesting, and I think the jury will begin deliberating tomorrow. I'm guessing they'll get released after these today, and then they'll get to deliberations tomorrow. Who knows when we'll have an answer? I'm guessing Wednesday because Thursday is Thanksgiving. So join us again, and we'll see you soon. Thanks for watching.